associate with our firm and also the lead attorney in our litigation department. We'll be providing you updates today on what's been going on in employment-based immigration and answering your questions. Stephen, what will we be discussing?
Yeah, so we kind of got four main topics we're going to discuss today, Rebecca. We're going to talk about the House passing the Build Back Better Act with the key immigration provisions and kind of what the process looks like moving forward and kind of some projections on that procedure there. We're going to talk about USCIS conducting an unprecedented third H1B lottery for the fiscal year 2022, or excuse me, 2022 lottery.
Yeah.
And then which charts USCIS is accepting for the December visa bulletin, and then some things to consider with regards to that. And then finally, just reminders here. We know we're getting close to holiday travel season and things to keep in mind from an immigration side.
Okay, sounds good. So for our first topic, the House passing their version of the Build Back Better Act. So that's the budget reconciliation bill that we've been discussing for several weeks. And the good news is that this version of the bill that the House passed last Friday does include key immigration provisions that would greatly benefit employment-based applicants if they do get passed and become law. So those provisions that we've discussed before include the recapture of prior unused green cards. That's in the employment-based and family-based categories going back decades, recapturing those unused green cards that have gone to waste in the past, and a provision that would allow applicants to actually be exempt from the green card cap if their priority date is older than 2 years old, and they could file for adjustment of status right away once they meet that 2-year mark with an additional filing fee. It also includes over $2 billion to USCIS to try to relieve the backlog, to give them more resources to process the applications that would be coming in as a result of those measures. So those are all, really great provisions that would help a lot of people in the employment-based green card backlog. So that is just the House version of the bill so far. Where are we concerning the Senate version right now?
Yeah, so, I mean, now that it's passed the House, it goes over to the Senate, and we kind of anticipate that there may be some changes, hopefully not too many, so it can get through easier. But kind of one of the key steps, especially on the immigration side, Rebecca, is going through the Senate parliamentarian. Right. We know from the last two, Plan A, Plan B, that the Senate parliamentarian has rejected those from various reasons, and basically her job is kind of the referee, if you will, on what can and cannot be considered in this budget reconciliation side of things. So my understanding is today there was kind of some informal meetings, and I believe what we've heard is that there's potential that they're going to kind of present this in phases, potentially some of the more not concerning, but more the sides that she has concern, the parliamentarian has concerns with, before it goes to the remainder that are, the employment recapture, right? That's a little more benign and less controversial, I guess is the word.
Right, yeah, so this Plan C that the Democrats are apparently presenting to the Senate parliamentarian, it sounds like kind of one of the main sticking points is this parole provision that would allow immigrants who have been in the U.S. physically from 2011 onwards to apply for parole and work authorization. That is also part of the House version of the bill. That sounds like that's what is mostly being discussed with the parliamentarian. So going forward from here, the Senate will be in discussions and putting together their version of the bill. As far as the timeline, it sounds like not necessarily in the next few days or week, but by the end of the year, just a month from now, there's expected to be a Senate version of the bill. So right now, these upcoming couple of weeks are the crucial time that people should be contacting their senators and advocating for the inclusion of these same immigration provisions in the Senate version of the bill. The advocacy efforts of the past several weeks, months, we see how it did lead to the inclusion of these really common sense, long overdue measures in the House version of the bill, and so we need people to contact their senators to advocate for the same in the Senate version of the bill. And there will be a description, a link to a template letter that people can send to their congresspeople in the description of this video.
Just one more note, the reason it is important to contact your senator is just the parliamentarian is not the end-all be-all. She does make a ruling on the inclusion of these, but it's not binding, right?
Exactly.
It can be overturned by the senators, and it still requires the simple majority with budget reconciliation.
Exactly.
So be sure you're reaching out.
Okay, so Stephen, what's going on with the H1B Lottery?
Yeah, so
kind of
every year when they do the H1B Lottery, we kind of are now with this new system. We were curious, is there going to be a second round? There was this year, and then we thought we were done with it, and then Friday we get a third round of selections. The USCIS sends an announcement saying we've conducted a third H1B lottery for the fiscal year. So what does that mean? Obviously they're not getting enough of the applications, so they've done another round of lotteries. Check with your attorney that did the registration. Check with your company. Both should be getting an email about there's actions taken on a case, and then they can look to see if yours was selected. In terms of the filing window, right? So you get a 90-day filing window that started from yesterday and will go all the way till February 23rd, 2022. To get your filings in with USCIS, and those are hard deadlines, right? So, we've seen instances in forums or consultations that somebody mailed theirs on the day before and it got delayed because of FedEx and not there on time. So get it in early for two reasons. One, you don't want to deal with the mail issues. If it's there even 1 day late, they'll reject it and there's nothing you can do about that. And then number two, we are talking about these final deadlines being February 23rd, and the registration window for next year's lottery is going to start in March. And so, if you file early, you could have a decision on your application to know if you're going to have to proceed with another registration. That said, if your case is for some reason taking a while, I don't see any issues, Rebecca, with filing a registration in next year's lottery.
Yeah.
It's not that, because you're doing it over multiple lotteries, is not the dual multiple filings that we always talk about on Facebook Live that we try to recommend you don't do because it is two different lotteries. And so if your petition is still pending, it may be worth the little bit of money it is for the registration to play it safe and enter the lottery again in case your case gets denied, for whatever reason.
Right.
And Rebecca, so December Visa Bulletin came out, I think, a week or two ago. We were waiting to see USCIS, which chart they're going to use, what are they going to do, and what are some things people might want to consider now that we're getting to the middle of kind of the fiscal year? Yeah,
so we were waiting to hear from USCIS on whether they would use the filing dates chart or only go by the final action dates chart. They did confirm at the end of last week that they'll be accepting the filing dates chart for December's Visa Bulletin, that's chart B. So based on our previous observation of the Visa Bulletin, these early months of the fiscal year are when USCIS is more likely to accept the filing dates chart. Typically, I would say usually October, November, sometimes December is when they accept that filing dates chart. So they are accepting it next month, but we wouldn't, if anyone is considering using chart B, for example, if your priority date is between 2012 and 2013 and you're considering filing in EB2, for example, if you're considering filing a new set of I-485s in the EB2 category, if you maybe had an EB3 filed last year, don't wait for the final date to become current because we don't know how much longer USCIS will allow using chart B. I would expect that most likely by January they will go back to using only the final action dates chart. So if your date is current according to chart B and you're thinking of using that chart B date, go ahead and make sure your application for the adjustment of status is filed in December. And then our last topic we wanted to cover is just some tips for anyone traveling internationally over the holidays for this month and next month.
Yeah, so, we fully recognize we're getting into holiday season, we're getting into travel season, people want to go spend time with their families, but just some things to consider before you make that decision. Number one, if you have to get visa stamping, consulates right now are incredibly backlogged all over the world, right? And then even some are not operational because of COVID conditions in that country. They're only open for emergency appointments, or you can't get a visa appointment for another year. So keep that in mind before you travel, that it may be hard for you to get that visa stamp. If you qualify for Dropbox, we know the Dropbox has been expanded to, generally you can only do it for if your visa has expired within the last 2 years. As part of the COVID policies and kind of protocols that they've done, they extended it to if your visa had expired within 4 years. That extension ends December 31st of this year. It may be extended, but as of right now, we don't know that. So Dropbox, maybe again limited to the 2 years. Once we get more information, we'll let you know. Another thing to consider is that when the Biden administration withdrew the travel bans from countries with high COVID cases, what he put in was a global requirement that folks entering the United States have vaccinations and proof of a negative COVID test. Not all vaccinations are being accepted. It has to be one of the FDA approved cases, like FDA approved, which are the Moderna, Pfizer, Johnson & Johnson, or the World Health Organization approved cases, which include the AstraZeneca and some of the other ones that we've got listed on our website. So keep in mind, not only are you going to have to do that, but upon entering the United States, you'll have to show a negative COVID test from 3 days prior, I believe. So just make sure you keep those in mind. And then there's limited exceptions to this vaccination policy. So you can just keep an eye on that. You've got to get the vaccine in order to come in for the most part. Obviously, kids that are not qualified, will be exempt. So Rebecca, do you want to take? We've got some questions here, it looks like.
So we'll start with Santosh from YouTube is asking, what is the average time to get a receipt number for an I-485 filed in the EB2 category? So actually, based on our experience, it's not really the employment-based category that really makes a difference in how long it takes to get a receipt notice for an I-485 application. It seems to depend more on the location where the I-485 application is mailed. So a lot of I-485s are mailed to the lock boxes, the Phoenix, Chicago, or Dallas lock boxes, and we have observed that it's taking longer for the lock boxes since October, I would say, to issue receipt notices and even to cash the filing fee checks. If you're checking your bank records to see if the filing fee check is cashed, sometimes it's taking a couple of weeks just for them to deposit the fees, and then maybe another month or so to get the receipt notice. So that's from the lock boxes. I would say if you're filing with the National Benefits Center, those RFE or receipt notices do tend to arrive a little bit faster.
YouTube question from YouTube. I-140 is approved 15 days back. EB2 to EB3 downgrade. Priority to 2011 September. Biometrics done. When can I expect a green card? It's always hard to predict, especially once it gets to the field office. It's not something that there's a great. It could be tomorrow. They could call you in for the interview. It's not an easy way to predict. I think we're out of the business of predicting how long things will take on the green card side.
So we have a question from someone who had an RFE on their EB1 I-140 concerning their education. So it is pretty difficult to answer kind of what would be done in that case because there are different categories in the EB1. I'm assuming you are referring to the EB1A category for aliens of extraordinary ability. If it's related to your credentials, then it's not just going to be a matter of your degree or your education. For that category, you have to demonstrate a pretty extraordinary level of achievement in your field of study or your field of endeavor. And so you'll most likely need to provide a lot more evidence beyond just your degree certificates about your qualifications for that category.
Question we have from YouTube. People with 485s pending at Nebraska Service Center or the Texas Service Center, can we file a class action lawsuit to speed up the 485 processing? I'm going to tell you that's a very difficult case for a lot of reasons, especially in light of recent court decisions coming out of those two courts. In order to sue on benefits that are delayed, it has to be something that the government is required to take. It's got to be a discrete action that the government is required to take. For 485s, for adjustment of status is a discretionary benefit. They don't have to do adjustment of status within the United States. They can require you to go consular process your green card. Because it is a discretionary benefit, courts have often held that there's no jurisdiction over delays of those cases. And we saw that with decisions coming out of the Texas Service Center and the Nebraska Service Center courts that were denying temporary restraining orders, dismissing cases because there is no jurisdiction over 485 delays. It's not to say it's impossible, it's just going to be a very difficult hurdle to overcome, and it's why we tend not to recommend those cases at this time. That's different from the interim benefits, right? The EAD, AP that are pending and are taking a year. Those are required actions. They're ministerial. They take, I think, 15, 12 minutes each. And we've done a few of those cases, and those are different from the 485. So the interim benefit cases you can still pursue.
Anand is asking about moving back to a previous employer, whether that previous employer would need to start the green card process from scratch if he has started the green card process already with his current employer. That will depend on whether your previous employer started the green card process for you also and how far they got. If your previous employer did get an approved labor certification and an approved I-140 and they never withdrew it, if they are still offering you the same position described in that approved I-140 petition, you can always return to that employer, and if and when your priority date becomes current, you can file the I-485 application with their J supplement confirming that they're still offering you that position, and they wouldn't need to, refile anything, really, the old employer. They would just need to provide a J supplement. If they did do the perm process, got the I-140 approved, but then withdrew your I-140 approval after you left the company, there's still a possibility for you to kind of resume the green card process with that old employer, as long as the I-140 with that old employer was filed on time in the 6-month window after the perm certification. They may not need to redo the perm from scratch. If they're still offering you the same position described in the perm form, they can file a new I-140 based on that approved labor certification, even if that approved labor certification is from several years ago.
Question from Facebook. Do we expect EB3 priority dates to catch up with EB2 priority dates towards the end of the fiscal year? I know Rahul always says, we're going to stay out guessing on the visa bulletin, but if I had to make a prediction, I'd probably say no. When we saw one of the most recent chats with Charlie, they've already had, the reason we saw the retrogression is because they already had enough EB3 India petitions to cover this fiscal year. Which is why we're not seeing the movement. So in my opinion, and Rebecca, please, if you disagree, my opinion is if we're going to see movement on EB3, it's going to be next fiscal year. Yeah,
that would be my guess as well. Sam from YouTube is asking about, it looks like his priority date was printed incorrectly on his I-140 approval notice. Is that an issue? So we have noticed the same, actually. Unfortunately, it's not, it does seem to happen every once in a while. We've had I-140 approval notices that had the incorrect priority date, like the date that the perm with that application was filed instead of the older ported priority date, even though we included the request to port the priority date in the I-140 petition. So it does happen. It's not too big of an issue. You can ask USCIS to correct it and issue a corrected approval notice. We've had kind of mixed results on that. I would say if the I-140 was filed in premium processing, there's a better chance that you'll get the corrected I-140 approval, or at least in a reasonable amount of time. If your attorney or your petitioner emails the premium processing unit where the I-140 was filed, they can usually correct the approval notice pretty quickly and send you a new one. If it's in regular processing, it's a much more up in the air situation on whether they'll issue a corrected approval notice. It's much more difficult, but it doesn't affect your eligibility to file based on the older priority date. So your party date is still considered the older party date that you requested to be ported. If it gets to a situation where your party date is current and you're ready to file the I-485, but the corrected I-140 approval notice has not been issued, you can submit the I-140 approvals, all of them, and include an explanation that, you know, there was a request to port the party date. It's just printed incorrectly on this most recent I-140 approval, but you're still eligible to file according to that party date.
We got a question on Facebook. My spouse has pending H4 and H4 EAD extensions that are expiring at the end of this year. In light of the recent policy change, will she get any benefit of the 180-day automatic extension? And the answer is no. In order to qualify for the 180-day automatic extension, you have to have your underlying status I-94 extended beyond the date of your EAD expiration. So for example, if your wife's EAD expires in March of 2022 and her H4, because she traveled and got it extended recently, expires in 2024, you could file the EAD extension and you'd qualify for that 180 days. And so the follow-on to that was, what are the options to expedite? Mm-hmm. You know, we do have still a pending class action case, the same group that did the L2 case, you know, with between us, Wasdabanis and Ayla, that it's focusing on the delays of the I-539s for H4s and L2s, as well as the H4 EAD delays. And that's fully briefed. We're just waiting on the judge on that one.
Okay. Swati from Facebook is asking, have we seen anyone getting their green card approved who had their interview done after the party date retrogressed? So I have been in I-485 interviews in the past that got scheduled and then the party dates retrogressed. I would say typically in that situation, what will happen at the end of the interview is that the officer will let you know what they're recommending. If everything is fine with the interview and the application, they can say that they're recommending it for approval, but that they cannot grant final approval because a visa number is not available at this time. So that's more likely what's going to happen if you are interviewed after your party dates retrogressed. You should still attend the interview and be prepared with everything you need for the interview, but you may not be able to receive the green card if the dates are retrogressed. Kind of an exception to that we have heard a few instances of recently are there have been some cases where for some reason families who filed their employment-based I-485s together, like maybe parents and a child filed all their I-485s at the same time. And while the party dates were current, like maybe in September, the parents got their I-485s approved and the child didn't for some reason. I've also had a few cases like that where for whatever reason it took an extra few months for the child's I-485 to be approved, and we just have to keep following up with USCIS. But in those cases, the child's I-485 was approved even if the party dates were retrogressed by that time, if the principal applicant's I-485 was approved when the party dates were current.
Question on YouTube, and we see this a lot. Any update on H4 EAD premium processing? Unfortunately, no.
Yeah.
You know, it's sitting at the rule stage. We've not seen any movement. We've asked about it in litigation, you know, if they can give us a date that they anticipate, you know, putting forward that regulation, and we've kind of gotten silence on that. Mm-hmm. It's really in their discretion. And keep in mind, right, just because it's on the regulatory agenda doesn't require action. If you recall, you know, the entirety of the Trump administration, the regulation to get rid of the H4 EAD was on the regulatory agenda and never was even proposed. Mm-hmm. And it's off now, right? So don't worry about it. It's off right now. But you know, hopefully they come out with that soon. But there's no mandate on when they have to put it forward.
Yeah. Let's see. Anurag from Facebook is asking, is it possible to use an advanced parole without using the EAD? So there is a kind of a specific situation where you can possibly re-enter the U.S. using your advanced parole and then continue working using your H1B or your non-immigrant status, whatever you had prior to departing the country. So that is only possible in a situation where at the time you departed the US and are coming back into the US, for example, if it is H1B, if your H1B validity period and you have an H1B I-94 that is still valid at the time you're coming back into the country on advanced parole, there is a memo that says that you can file an H1B extension in that situation without having to leave the country, get an H1B visa stamp, and come back in. So that is possible, but it's only in a situation where your H1B is still valid beyond the date that you're re-entering using the advanced parole.
Question from YouTube: are we seeing any I-485 approvals for EB2 to EB3 downgrades that we filed in October, November from the Texas Service Center? And I believe, if I remember right from a meeting a week or two ago, we've started seeing some trickle in. It's slow, right? It's not a high percentage. It's a small number, but we have seen some trickling in.
Right, for the I-140s?
But I believe, I think for the I-140s, I think we've seen some of the 485s, but it's a small number. It's like one or two, but there's hopefully getting to that point.
Yeah, starting to, but unfortunately, the majority, I would say, of the ones filed last year pending at the Texas Service Center are still pending.
Right.
Slowly, they're starting to get movement. Let's see. Okay, so Tusha from YouTube is asking about potentially qualifying for the EB1C category if he moves outside the US for a year and porting his priority date from an EB2 I-140 petition. So that is technically possible. We usually recommend that people considering that discuss pretty carefully with their employer and an attorney to be aware of all the requirements for the EB1C. So the EB1C category is for multinational executives and managers. It requires that the beneficiary have worked for at least a year in a foreign country in a managerial or executive position for a parent, subsidiary, or affiliate of the US company. And then if you come back into the US, you need to be sponsored at least for a managerial position in the US. So it is possible, and if you do qualify, you can definitely port your EB2 priority date to a new approved I-140 petition in the EB1 category. But we do have quite a number of warnings to the company and the beneficiary when they're considering that, so I would definitely recommend that you discuss in detail with your company and an attorney.
Question from YouTube: wife got an RFE on the birth certificate, but having a hard time getting all the documentation. RFE deadline is approaching fast. Is there a way to ask for an extension? There's not a way to ask for an extension, but keep in mind that the RFE date that is on your notice with the kind of COVID conditions with USCIS, they are adding 60 days to all responses for RFEs, any appeals, anything like that. So whatever the deadline that is printed on the RFE notice, you can add an additional 60 days to that. And that's the true deadline given this policy right now.
Roshan from YouTube is asking about his pending downgrade in I-485 applied last year, and can he take a new role within the same company? Is a new perm required? So that does depend a bit on the difference of the new role, how different it is from the role described in the I-140 that was just filed in October 2020. If it is arguably within the same SOC code, we would say usually a new perm probably is not needed. There is a situation where you could use AC-21 with the same company. So usually we talk about AC-21 in a situation where you switch to a new company after your I-485 has been pending for 180 days. The same could be used even if you're not moving to a different company. If you're moving to a different position within the same company, you could also use AC-21 for those purposes, as long as the occupations are same or similar. again, it requires that your I-485 be pending for 180 days, which it is in this situation. Another thing that we normally recommend is waiting until the I-140 is approved before using AC-21. In this situation, I believe you mentioned that your I-140 is still, oh, actually, I don't think you mentioned whether your I-140 is approved or not. If the I-140 downgrade is approved, I would say there's no problem using AC-21 to take a new position within the same company. If it's not yet approved, just be aware that you may be required to prove that that I-140 was approvable, even if it's with the same company.
Question from YouTube. Applied for I-485 at the Texas Service Center 9/24/21. Received receipt numbers about a month later. Still haven't received biometrics. What do I need to do? Unfortunately, you're really just in a situation where you have to wait. Biometrics, for most of them, we're seeing about 1, maybe 2 months after the receipt notices. For the most part, but they are coming. So just stay patient. If after probably the turn of the year, and remember, we've got holidays coming up that are going to limit some of the service centers. But if you haven't received it by February, definitely reach out. But right now, you just got to kind of wait on it for now.
Ryan from YouTube is asking, how long does FBI clearance for an I-485 take, and is there a way to determine if it is completed? As far as I know, there is not really a publicly available way to look up whether your FBI security check is complete for purposes of an I-485 application. At most, if there isn't any issue with your FBI security check, I would say the processing time is pretty normal. Overall, we don't really find out that it's been done. It's just part of the normal processing of the I-485 application. The only time we really hear about it is when an I-485 or any other application ends up being pending for an extraordinary long period of time, like an absurdly long time.
Like more than a year. I mean, we're talking 2 years that, for a 485.
Yeah, and in those situations, usually there have been e-requests, outside normal processing inquiries, congressional liaisons, sometimes getting the USCIS ombudsman involved before we find out from USCIS that it's taking a long time because of a security check. But it's usually at that point before we find out that information. It's not something that, it's not like the case status on the USCIS website that you can look up for yourself. So I'd say if there's no problem with the security check, it'll just be part of the normal processing time. It's only if something is wrong or unusual that it will take a much longer period of time, and at that point it's pretty much indefinite. There's no set time on when they may be done.
Husband on YouTube, is it safe to do 2 jobs on an approved EAD? Gonna assume we're talking about an adjustment of status EAD, if it's a F1 that's, limited to that. But H4, L2, the C9 EADs, those are unrestricted rights to work. You work 3 jobs if you want to, work, wherever you want, work at a library, work at NASA, whatever you want to do, as long as it's a legal enterprise, you're okay to work at it.
Rob from YouTube is asking, is there a way to know if your case, I assume the I-485, has been moved to the field office, and that Emma and online agents don't provide any information? He's considering moving to a different city and wants to know if the change of address would delay the process. Unfortunately, I also don't know if there is a way to determine if and when your I-485 file has moved from a service center to a field office, unless you receive a request for evidence or some other courtesy letter or notice from the field office asking you to provide something additional, like a medical exam. That's usually the only time we know that the file's been moved, because we get an RFE from a field office in a particular city. As far as changing your address and whether that will delay the process, I would say that will depend on how far along you are in the I-485 processing. If it has been pending for over a year and your biometrics are done, your medical exam is submitted, your I-140 or your immigrant petition is approved, and if your party date is current according to the final action dates chart, It's possible. I mean, there's nothing standing in the way theoretically for your I-485 to be approved at that point. Those are the main things that need to happen. And if it has been pending for at least 6 months, I would, it could be any day that the I-485 could be approved. And even though you should be able to change your address and have USCIS update your address in a timely way in their system and not have issues, but I have unfortunately had clients who it took months for USCIS to update an address change in their system. They, for example, got fingerprint appointments to an address that they had moved away from 3 months prior, even though we had submitted the change of address request immediately. So in that situation, if your I-485 approval is imminent, from a practical standpoint, I would lean towards waiting until, it's hard to say because we don't know when, but if you can wait, I would. If you're in a situation where your priority date is retrogressed and we don't know when it will become current again, I would say go ahead and change addresses.
Yeah, and on the change of address thing, one tip that I've given folks is to do the AR11 that you're required to do, and then probably within about 3 weeks, call USCIS and try to confirm. I've had plenty of conversations with USCIS customer service lines where they're saying, we're not tracking that, and I've got the notice of the AR11 being done.
Yeah.
And that's just always the backup. I always tell them, I know the phone system's hard to manage, but it's worth double checking. Question from YouTube, 485 is pending, I-140 approved. In case your salary is less than the prevailing wage, because it could result in a denial of the 485. Keep in mind your green card that you're filing for is for, considered, right, with the I-140, a future job. So if you're working on H1 or L1 right now and you're making a little bit less than what the prevailing wage came back for your EB2 I-140, I don't think that's going to be a problem, because again, it's a future job.
Right. Radhika from YouTube is asking about interfiling. So it sounds like her party date is current in EB2 and she would like to try interfiling, but the employer wants to use a different attorney, not the one who filed the I-485 initially, to submit the interfile request, and will that delay anything? I would say it most likely won't really delay anything, because the interfile request anyway is, even if it's the same attorney sending in the interfile request, they are sending in, a previously approved I-140 approval notice and a letter to the service center where your I-485 is supposed to be pending, just according to the receipt notice, and asking USCIS to match up that I-140 approval notice with your I-485 file and to take action on the case because the priority date is current. Even filed by the same attorney, there's no way to know for sure whether they will actually match up those documents with the file. As we said before, we don't know if the file has moved to a different office by then. So the only difference in filing the interfile request through a different attorney is that they would include a G28 along with that letter. And so it's, a same thing of matching up the same set of documents with the file. I would say doing it through a different attorney really won't delay anything. If it does end up delayed or seems like it's taking a long time, I would say that's more a function of it being an interfile, just the fact that it's a very opaque way to try to update your file. They don't give a receipt number or any information or updates really on if and when an interfile has been done.
And the one benefit that with interfiling that we've done on any types of cases of having a G28 is it less likely it gets thrown away in the mailroom.
Yeah, true. Mm-hmm.
There's not a official form you're filing with interfilings. It's kind of a working theory everybody goes through.
Yeah.
So it's sometimes those mailroom folks need a little reminder not to toss it out.
Yeah.
Question from YouTube. Employer withdraws I-140 after 180 days. Does the new employer need to file the perm labor and I-140 as the previous employer's I-140 is no longer valid? So once the I-140 has been approved for 180 days and then they withdraw it, any new company, in order to sponsor you for a green card, is going to have to go through that whole process again. They're going to have to go through the perm. They're going to have to file the I-140 in order to sponsor you. What you get is the retaining of the benefits after that 180 days. So your spouse can still file for the H4 EAD. You can qualify for the extensions beyond the 6 years, and you can still port your priority date. So that's the benefit. But like I said, any new company is going to have to start the process over again to get everything certified.
Sarita from YouTube is asking about a denial of an L1B to L1A conversion, and can it be refiled? So if you were filing for a change of status from L1B to L1A, it kind of depends on where you are in your 5-year limit. As you probably know, the L1B status has a total 5-year limit. The L1A has a 7-year limit, and so sometimes we do see people converting from L1B to L1A in order to get an extra 2-year extension. If you are basically at the end of your 5 years or have already used up your 5 years of L1B time, you probably won't be able to refile again in the US. It may be necessary to leave the US and wait for at least a year and work for your prior company's affiliate in the foreign country before you're able to reapply for L1A.
Question from Facebook: priority date March 2012, filed downgrade in August with EB3, refiled EB2 and got receipt notices today. EB3 biometrics done. When should I withdraw the EB3? I don't think you have to. We've talked at length before. You can have multiple 485s pending. There's nothing wrong with that. You've already paid for them, and then see which one eventually gets approved sooner. I don't think you have to withdraw.
Let's see. So just lost the question that I had my eye on. So there's a question from YouTube on whether you can travel outside the US while an adjustment of status is pending using a valid H1B visa stamp. So yes, that's fine. If you are in valid H1B status and you have a visa stamp in your passport, you can depart the US and come back in on H1B without your I-485 application being considered abandoned. If you'll be coming back when the H1B has expired, then you need your advanced parole approval in hand before you depart the US. But if you are leaving and coming back in valid non-immigrant status, H or L status, you can do that without having an advanced parole. If your I-131 application for advanced parole is pending at the time you leave the US, just be aware that that might be denied because USCIS has been denying I-131s when the applicant leaves the US before it's approved, and that could take about 4 to 6 months for it to be approved. So just be aware that when you're back in the US, you may need to refile the I-131.
Yeah, they by policy, that initial advanced parole is abandoned once you depart the United States. Now, if it's an extension, it's different.
Right.
But that initial one is going to be abandoned. Question from Facebook: can you let us know the employment-based clauses that were in the reconciliation? But we talked about it at the beginning. My understanding is it's still kind of what we've expected from the Congress. We've got the recapture of unused employment-based green cards. Remember, we had 82,000 just last year, and this is going to go back many years for recapture of employment-based green cards. It's going to include the House bill, right? Included the provisions for the paying the extra money to avoid waiting in the backlog. And those are the biggest provisions, I think, from the employment-based side,
right.
That are available right now.
Vishal from YouTube is asking if his previous employer has withdrawn his I-140 after 180 days. Does the new employer need to file a new labor certification in I-140? So that depends on whether you have filed the I-485 application as well. If your I-485 was filed and was pending for at least 180 days. So that's the pending time for the I-485. And then you move to a new employer. Even if the previous employer withdraws the I-140, then AC-21 allows you to kind of continue the I-485 without a new employer having to start the perm and I-140 in their own name. They just need to file a J supplement to USCIS attesting that your position with them is in a same or similar occupation as your previous I-140 position. If your I-485 has not yet been filed and it was just an I-140 approval that was withdrawn after 180 days, if you move to a different employer, then that employer does need to start the perm and I-140 for you in their name. The benefits that you can retain from that prior I-140 that was withdrawn, if it remained approved for at least 180 days, then you can still use that I-140 for purposes of H1B extensions beyond the 6th year. You can use it for a spouse's H4 EAD application, and you can still always port the priority date from that prior I-140 to a new I-140 petition. That doesn't even require the 180 days.
Question from YouTube. If I got my employment-based green card, but my dependent has not received her green card, could she continue to work on her H4 EAD? I don't think she can. Once you've converted, once you got that green card, you are now you're now a lawful permanent resident, and no longer on H1B. And since you're no longer on H1B, your spouse can no longer properly maintain H4 status. And therefore she can't work pursuant to her H4 EAD.
Yeah, I would agree. Santosh from Facebook is asking, does USCIS issue I-485J receipt notices for everyone who applies, or are there cases where the I-485 gets approved without a J supplement receipt or approval? That is a good question. We have been noticing kind of inconsistent issuance of J supplement receipts, I would say, this past year. I actually received some receipt notices for the J supplement recently for I-485s that were filed earlier this year. It had been like 4 or 5 months after the I-485 was filed, and we received the I-485, I-765, and I-131 receipt notices within a month or so of filing. And then we received the J supplement receipt notice suddenly about 5 months later. I'm not really sure why. USCIS seems to be taking longer sometimes, or not sending the J supplement receipt notice at all. I would say it doesn't really affect the overall I-485 as long as it was filed and pending with the I-485 application. It should be fine. If it didn't get matched up to the I-485 for some reason, I assume they would send an RFE asking for it. But it may be because the J supplement on its own is, it's kind of part of the I-485 form, so that may be why different service centers or the lockboxes are not that consistent on sending those receipt notices. But if you got an I-485 approval notice, I would consider that your green card is approved. Don't worry that you didn't get a J supplement approval notice.
A question from YouTube. Somebody's heard of people getting their green cards after the retrogression, and they're still submitting medicals. Any issues? So first off, if you get an RFE or you get biometrics or you get an interview, do it. Take whatever steps you're given by USCIS, even though there's been retrogression. And in terms of getting your green card after the retrogression, you got the green card. I mean, it's there's no issues with that.
Yeah. Yeah, I would say
I mean, there is, even though we saw the big retrogression right back a couple months back, that doesn't mean that it's 100%, right? There could still be some cases that were approved and we're just waiting printing, or the officer had signed off and just hadn't processed it or whatever.
Yeah.
There could be all these administrative reasons that some are still getting processed, even though the chart came out. Remember, just because the chart came out in the middle of the previous month, there were still weeks where, there were visas theoretically available.
Yeah, like I said, in my experience, I've noticed that more in cases where it was families. So if the principal applicant's I-485 was approved before September 30th, I have sometimes seen the I-485s for spouses or children get approved after October 1st, after the date's retrogressed. But usually that was in a case where the principal applicants was approved first, and so it seems like the officers kind of assigned the visa numbers to kind of that whole family before September 30th, and then maybe the final approval for the derivatives came in after October 1st. But yeah, as a general rule, I would say that isn't, for the most part, it's not common.
Yeah, it's going to be very rare circumstances.
Okay, there's a question from Maheswara about his EB3 downgrade that is still pending. Oh, it looks like actually his I-140 was approved and he's done the biometrics. Wants to know if he should apply for the I-485 in the EB2 category. So Raul and Emily in previous sessions have gone through kind of the pros and cons of interfiling versus filing a new I-485 application in the EB2 category. So we have actually a whole video on that subject alone. As far as whether it's better to file a new I-485 in the EB2 category, definitely if your priority date is not yet current in the final action dates chart, we don't recommend interfiling. So interfiling should be done in a situation where your final action date is current according to EB2, for example, so that you can send in that interfile request and tell USCIS, there's a visa number available for me in EB2, please approve my I-485 in that category this month. If it's not yet current there, but it is current in the EB3 category, in the EB2 category according to the filing dates chart, yeah, you could file a new I-485. I would say it definitely doesn't hurt anything. Kind of the main downside is submitting a whole new set of filing fees, and the fact that an EB2 refile starts from 0 as far as processing time. It starts from day 1, and so you may have another year or so processing time upcoming. You will probably have to submit medical exams again, do the biometrics again, possibly if they don't use your already captured biometrics. But if EB3 continues the way it is, kind of not really moving, it may be worth it to file a new set in EB2.
Question from Facebook: where can I find the draft letter to be sent to the Senate? A couple things on that. One, call as well. This is going to be coming up here soon. Call your senator's office and ask for the employment-based provisions to be included in the immigration provisions with the Build Back Better. And then in terms of the letter, I believe, is that if we've got it on our website or on Emily's blog. So check out our website, rnlawgroup.com, and you can find it on there.
Yeah, so it should be in the description. The link should be in the description below the video. It's a template letter. One thing that we always emphasize is that even though it's a template, kind of the main purpose of the template is so that we can provide you all with the specifics of kind of the technical language of what exactly we want included in the Senate version of the bill, as far as the visa recapture, the exemption from the overall green card cap, that sort of thing. But it's very important that you all personalize the letters that you send, kind of these communications that you send to the Congress people. Your personal immigration journey that you've been on for the past 10 or however many years, that is specific to you, and as a constituent for your senator, that's very important to incorporate into that template and include in there, so that that gets across to the senators that these immigration reforms are not just just a technical thing, but it's affecting you and your family. It's affecting families, really. It's not just businesses that get affected.
Yeah, and I think that was one of the I saw one of the senators say, businesses getting green cards. Well, businesses don't get green cards.
Exactly.
You as an individual can take your green card and start a business, but talk about how this would positively impact your life, and to try to push for that change in your children's life if they're impacted as well. Question from Facebook: any updates on Dropbox eligibility, which is current until December? So Dropbox is available all the time. It was just the extended. There was an extension on how long your visa could be expired that came about because of COVID. We have no updates on that if that's going to be extended again. If it were me, I would, right? Until these consulate offices can operate at full capacity. I would extend it, but I'm not running Department of State.
Yeah, I would, if I had to guess, I would estimate that the State Department would extend it beyond the end of this year because the consulates worldwide are nowhere near at kind of a normal operating capacity. And so the more that they can process visa renewals through the Dropbox without requiring an in-person interview, the better it is for the consulates as well.
And we're seeing some countries go back down on lockdown, and that would impact
exactly.
the consulates as well.
And kind of final questions along the same lines of: can we predict EB2, EB3 final action dates in the coming months? Raul always says that he is the worst at guessing, so we are even less sure about hazarding a guess. All we can say is that based on the filing dates chart, so we do know that chart B in the visa bulletin, it's farther ahead than chart A because that is supposed to be based at the beginning of the fiscal year. That's where the State Department projects that final action dates will get to by September of the following year, of basically the end of the fiscal year. So if there isn't any significant immigration reform or some other significant changes, then we would, and if the visa bulletin proceeds at the pace that the State Department is estimating right now, we would estimate that EB2 would get to somewhere in July 2013, and EB3 basically would not move essentially at all for the rest of this fiscal year. So that's all we can kind of say, but that's just based on the filing dates chart, and we don't know for sure. We've also seen cases where the final action dates moved beyond actually what the State Department predicted in its filing dates chart, so that's always a possibility. So we're getting close to the end of our hour, so I think we will end the session here. Thank you for joining us, and you can tune back in next week. Our partner Reddy Neumann should be on the session at that time.